Picture a teenage girl sitting in a doctor's office, hands folded in her lap, waiting for an answer that could change everything. The fluorescent lights hum overhead. Her parents shift nervously in plastic chairs. Outside, the world continues its ordinary rhythm, unaware that inside this sterile room, a family is about to discover whether their child's future will be decided by medicine or by law. This moment exists in thousands of examination rooms across America. A conversation between doctor, parent, and child about what it means to grow up in a body that feels foreign. About treatments that have helped some and worried others. About the space between childhood and adulthood where identity forms like morning fog, delicate and real. But somewhere in the distance, gavels are falling. Legislators are voting. Judges are reading briefs that will transform these private medical moments into public legal battles. The teenager in the chair doesn't know it yet, but her story is about to become evidence. Her childhood, a case study. Her future, a matter of constitutional law. Because sometimes the most intimate human experiences become the stages where society argues about its deepest values. And sometimes a single lawsuit can redefine what it means to be protected under the law. The courtroom was quieter than usual that December morning. Snow dusted the marble steps of the Supreme Court building. Inside, 9 justices prepared to hear arguments in a case that would echo through every state capitol, every family dinner table, every doctor's office where parents and children wrestle with questions too complex for easy answers. This dramatized narrative is inspired by real legal principles and public case records. It is presented for educational and informational purposes, with interpretations attributed to their respective sources. The case bore a simple name that masked its profound implications: United States versus Skrmetti. Behind those words lay stories of families torn between medical advice and legal restrictions, of doctors weighing their professional judgment against state prohibitions, of young people caught in the crossfire between competing visions of childhood, identity, and protection. But to understand how we arrived at this moment, we must travel back to where it all began. Not in Washington's marble halls, but in the examination rooms and family kitchens of Tennessee, where ordinary people discovered that their most private decisions had become matters of urgent public concern. Tennessee in 2023 looked like America itself. Rolling hills gave way to bustling cities. Families gathered around dinner tables discussing homework and weekend plans. Doctors made their rounds, offering care with the same dedication their profession had maintained for generations. But beneath this familiar surface, a tension was building. State legislators had been watching national debates about gender-affirming care with growing concern. Medical associations defended treatments they considered standard practice. Parents found themselves navigating conversations they never expected to have. The law that would change everything carried an unremarkable designation: Senate Bill 1. Its language was precise, clinical, almost bureaucratic. Healthcare providers were prohibited from performing or administering certain treatments to minors. The stated purpose was protection. The practical effect, however, was significant regulation. What made this law different from typical medical regulations was its specificity. It carved out exceptions for certain conditions while creating absolute barriers for others. The same medication could be prescribed to one teenager but not another. The same doctor could treat one patient but not their sibling. The determining factor wasn't medical need or professional judgment. It was identity. 3 families decided they couldn't accept this distinction. Their children had been receiving care that their doctors recommended and that medical organizations endorsed. Now state law threatened to interrupt that treatment, not because the medicine was dangerous, but because of the reasons it was prescribed. These weren't activists seeking headlines. They were parents trying to navigate an impossible choice: comply with state law or continue medical care they believed their children needed. The weight of that decision fell heaviest on the young people themselves, caught between their internal experience and external regulation. One parent later described the moment they realized litigation was necessary. "We weren't trying to make a point. We were trying to protect our child. The federal courthouse in Nashville became the stage where private anguish transformed into public argument. 3 transgender minors, supported by their families and joined by a physician, filed suit against Tennessee officials. The legal theory was rooted in constitutional bedrock, equal protection under law. Their argument carried elegant simplicity. The same treatments prohibited for transgender youth remained available for other medical conditions. This created 2 classes of patients receiving different treatment under law, not because of medical necessity, but because of who they were. The Department of Justice, watching similar laws proliferate across multiple states, decided to intervene. Federal attorneys joined the case, transforming a family's private struggle into a national constitutional question. But Tennessee saw something entirely different in their law. State officials argued they were exercising traditional authority to regulate medical practice. The legislature had reviewed evidence, consulted experts, and concluded that certain treatments posed potential risks to minors. This wasn't discrimination. They maintained it was responsible governance. The initial federal judge agreed with the families. The law discriminated based on sex and created an unconstitutional classification. She ruled a preliminary injunction blocked enforcement, temporarily preserving access to care. Tennessee appealed immediately. The Sixth Circuit Court of Appeals saw the case through a different lens. The state law regulated medical procedures, not people, the appeals court determined. Age-based restrictions were common in medicine. Treatment limitations based on diagnosis were routine. The law survived constitutional scrutiny. The injunction was lifted. The ban took effect as you listen. Notice how easily this could be anyone's life. By the time the case reached the Supreme Court, it had accumulated the weight of national attention. 26 other states had enacted similar restrictions. Federal circuits had split on the constitutional questions. The justices faced a decision that would affect thousands of families across America. The oral argument scheduled for December 4, 2024, carried additional historical significance. Chase Strangio, representing the plaintiffs, would become the first openly transgender attorney to argue before the Supreme Court. This milestone wasn't lost on observers who understood that representation itself can be a form of advocacy. Strangio brought more than personal identity to the lectern. His legal resume included landmark victories in employment discrimination and military service cases. He had argued similar healthcare restrictions in multiple federal appeals courts. His preparation for this moment spanned not just months of briefing, but years of constitutional litigation. The questions facing the justices seemed deceptively straightforward. Does Tennessee's law violate equal protection? What level of constitutional scrutiny should apply? But beneath these legal frameworks lay deeper questions about childhood, medical authority, parental rights, and the boundaries of state power. The federal government's position, articulated by Solicitor General Elizabeth Prelogar, emphasized the sex-based nature of Tennessee's classifications. Under the law, she argued, a male adolescent could receive hormones to develop masculine characteristics for certain conditions, while a female adolescent seeking the same outcome for gender dysphoria could not. This differential treatment based on sex demanded heightened constitutional scrutiny. Tennessee's defense rested on different ground. The law regulated medical procedures, not identities, state attorneys argued. Age restrictions protected minors from potentially irreversible decisions. The legislature had acted within traditional state authority to oversee medical practice and protect children. But the legal arguments only captured part of the story unfolding in that courtroom. Behind the constitutional theories lay competing visions of childhood itself. One side saw young people capable of participating in complex medical decisions with parental and professional guidance. The other emphasized protection from choices they might later regret. The justices' questions revealed these underlying tensions. How should courts balance medical professional judgment against legislative determinations? What deference did states deserve in regulating health care? Could constitutional principles resolve what were fundamentally disagreements about medical practice? Justice after justice probed the boundaries of each position. The conservative justices seemed skeptical that constitutional law demanded specific medical treatments. The liberal justices questioned whether states could simply invoke child protection to justify classifications. In the middle sat Justice Barrett, whose question suggested she was weighing how constitutional principles applied to rapidly evolving medical practice. Her vote, observers suspected, might determine the outcome. The arguments concluded without clear resolution. 9 justices would deliberate privately about questions that millions of Americans were debating publicly. The law would either stand as a legitimate exercise of state authority or fall as unconstitutional discrimination. But even as the justices deliberated, the political landscape was shifting beneath them. The presidential election of 2024 had changed more than party control of the White House. It had altered the federal government's position in this very case. The Biden administration had argued forcefully against Tennessee's law. The incoming Trump administration signaled a different approach. In February 2025, the new Department of Justice informed the Supreme Court that the United States was changing its position. The federal government would no longer support the plaintiff's constitutional challenge. Instead, it agreed with Tennessee that the law was a permissible exercise of state regulatory authority. This reversal carried practical and symbolic weight. Practically, it removed federal support for the families challenging Tennessee's law. Symbolically, it demonstrated how constitutional interpretation could shift with electoral outcomes. The justices, however, had already heard arguments under the previous administration's position. They would decide based on the legal theories presented, not the political winds that had shifted since December. On June 18, 2025, the Supreme Court released its decision. Chief Justice Roberts delivered the opinion in a courtroom that had witnessed history unfold in whispered conferences and careful deliberations. The marble columns stood silent witness to a moment that would reshape American law. The vote was 6-3. Tennessee's law would stand. The majority opinion, authored by Roberts and joined by Justices Thomas Gorsuch, Kavanaugh, and Barrett, concluded that the ban satisfied constitutional requirements under rational basis review. The court found that Tennessee's law created only 2 classifications that mattered: age and medical purpose. Neither, they determined, required heightened scrutiny. In careful legal language, the majority explained their reasoning. States possessed traditional authority to regulate medical practice. Tennessee had identified uncertainty in the medical community about these treatments. The legislature had responded to that uncertainty with age-based restrictions designed to protect minors. This was not discrimination, the majority concluded, it was governance. Justice Thomas filed a separate concurrence, emphasizing states' rights to regulate medical practice without federal interference. Justice Barrett, joined by Thomas, wrote her own concurrence focusing on the relationship between federal constitutional principles and evolving medical standards. Justice Alito concurred in part, making clear his view that employment discrimination precedents should not extend to healthcare regulation. The constitutional frameworks that protected workers, he argued, did not automatically protect patients. But 3 justices saw something fundamentally different in Tennessee's law. Justice Sotomayor's dissent, joined by Justices Jackson and Kagan, accused the majority of abandoning constitutional principles to political expedience. Her language carried unusual emotional weight for a Supreme Court opinion. The majority, she wrote, had abandoned transgender children and their families to political whims. The dissent's central argument emphasized the differing legal interpretations of how the law classified treatments. Under Tennessee's framework, male adolescents could receive hormones to develop masculine characteristics for certain conditions, while female adolescents seeking the same physical outcome for gender dysphoria could not. This, the dissent argued, was sex-based discrimination. Justice Kagan filed her own separate dissent, agreeing that heightened scrutiny applied but expressing no view on whether Tennessee's law would survive such review. Her measured approach suggested recognition that constitutional principles might clash with practical governance in complex ways. The dissenting justices emphasized something the majority had downplayed: the human cost of legal abstractions. Medical organizations unanimously supported these treatments. Parents and doctors had made careful, considered decisions. Young people faced interruption of ongoing care not because of medical risks, but because of legal classifications. As you listen, notice how constitutional language can make human suffering sound like policy disagreement. The Supreme Court's decision reverberated far beyond the parties who had brought the case. Within hours, legal analysts were parsing the opinion's language for clues about future cases. Civil rights organizations were calculating which states might expand their restrictions. Families were making decisions about whether to relocate or adjust their children's medical plans. The numbers told part of the story. Over 100,000 transgender young people now lived in states where their health care was prohibited. 26 states had enacted similar restrictions, with more likely to follow. What had begun as Tennessee's singular policy had become a national template. But statistics couldn't capture the human reality unfolding in examination rooms across America. Doctors faced choices between their medical judgment and state law. Parents weighed their children's immediate needs against legal consequences. Young people navigated adolescence while society debated topics far bigger than their individual experiences. The legal victory that Tennessee celebrated came with unintended revelations. During litigation, internal documents had surfaced showing that some legislators had relied more on political calculation than medical evidence. Expert witnesses had acknowledged that their opposition to these treatments was based partly on moral rather than medical concerns. The Supreme Court's decision had validated the outcome while leaving questions about the process largely unexamined. Chase Strangio, who had made history arguing before the Supreme Court, reflected on the decision with characteristic thoughtfulness. The legal system had provided a forum for these arguments, he noted, even if the outcome disappointed those he represented. Constitutional interpretation would continue evolving, he suggested, as society's understanding deepened. But for the families who had initiated this legal journey, the Supreme Court's decision marked an end and a beginning. Their children would grow up in a different America than they had imagined. The medical care they had sought to protect would remain inaccessible in their home state. Some families made the painful decision to relocate, others found ways to access care across state lines, turning routine medical appointments into complicated interstate journeys. Still others decided to wait, hoping that future elections or legal challenges might restore access. The three young people whose names had appeared on the Supreme Court docket faced futures shaped by constitutional interpretation. Their adolescence had become a matter of federal law. Their medical care had become a symbol of broader cultural conflicts they never chose to represent. The broader implications of United States versus Skrmetti extended far beyond gender-affirming care. The Supreme Court had established a framework for reviewing laws that restricted medical treatments based on patient identity. Future cases involving reproductive health care, mental health services, and experimental treatments would likely cite this precedent. Legal scholars began debating whether the decision represented a return to traditional federalism or an abdication of constitutional protection. Some praised the court for respecting democratic processes and state authority. Others warned that minority rights had been subordinated to majoritarian preferences. The medical community found itself in an unusual position. Professional organizations had provided expert testimony supporting these treatments based on clinical evidence and patient outcomes. The Supreme Court had acknowledged this medical consensus while concluding that legal considerations outweighed professional judgment. This tension between medical expertise and legal authority raised questions about the relationship between science and law. Could legislatures override professional medical consensus based on political concerns? Did constitutional principles require deference to medical organizations or democratic processes? The answer, it seemed, depended on which justice was writing the opinion. Perhaps the most profound aspect of United States versus Skrmetti was not what it decided, but what it revealed about the nature of constitutional interpretation itself. The same facts had supported entirely different legal conclusions depending on which framework the justices applied. The majority saw medical regulation and age-based protection. The dissent saw sex discrimination and constitutional violation. Both sides cited precedent, relied on established legal principles, and reached conclusions they believed were compelled by law. In the end, perhaps the most honest thing we can say about United States versus Skrmetti is that it exposed the complex and deeply interpretive nature of American justice. 9 human beings draped in black robes and armed with centuries of precedent looked at the same evidence and saw different constitutional outcomes. This wasn't failure. This was the system working as designed, imperfect, interpretive, and shaped by the perspectives of those entrusted to decide. The teenager we imagined at the beginning, sitting in that sterile examination room, will grow up in the America these justices shaped. Her story became law. Her childhood became precedent. Her future a footnote in constitutional history. But somewhere tonight, in another examination room, another family sits with folded hands and racing hearts, waiting for answers that law cannot provide, because justice, like morning fog, is both delicate and real. And sometimes the most profound verdicts are written not in marble halls, but in the quiet moments when ordinary people decide what they can live with. This is Beyond Verdict, where every case reminds us of a simple truth. Even justice casts shadows, and in those shadows we discover who we are.